Hello, everybody who's watching this on video. The request was made, a special request for me to record this session due to the fact that some people couldn't remain on and be a part of this mock trial session, which is our final mock trial session in the Law and Order Summer Enrichment. And it's been just a pleasure introducing everyone to it, but I think we all can agree that the amount of time we've been able to spend has only been a very immediate introduction. So what we've done so far is we've looked at the basic facts of the case. We understand it's a murder trial where the suspect is being charged with murder, but we looked at what the facts are, and there's some evidence that leans toward the fact that maybe this person killed their spouse because of problems they were having in the marriage that might also include motives having to do with the spouse's desire to end the business that they had started together due to the fact that a prototype of the product that they created resulted in the death of the spouse's child. And so we started to look at some of the prosecution, that is the side that wants to prosecute the case to put the suspect in jail for murder. And we looked at the witnesses, including the cousin who lives in the mansion with the suspect, as well as the police report. And there is one point I want to make before we turn our attention to the defense side of things. In a trial, there is something called an expert witness. That's different than just a person who is a witness. A witness is somebody who witnessed something, and they come to court to testify as to what they saw. An expert witness is somebody who did not witness the event, didn't see the event, but they're being called to the stand to give a scientific analysis of what they believe happened. And so if you're the prosecution in this case, we know that the issue at hand is whether the suspect took the golf club and whacked the victim in the back of the head, which then the victim fell into the bathtub and drowned. That's the case of the prosecution. We will learn that the defense, and I think we've started to see some facts point to the defense arguing that the victim was not struck on the back of the head by the golf club, but rather was drunk, slippery floor, continuing to drink, and slipped and hit their head on the trough of the shower or bathtub, which is where the water comes out. Instead of a spigot, it's a trough, and hit the back of their head and fell into the bathtub and drowned. So, while there are no witnesses to that event, the prosecution has a witness who was present at the house on the night of the event, and they have the detective who will discuss his investigation. But they also have an expert witness. And so if you're paying attention to the story I just laid out, if you're paying attention to the facts the way I just laid them out, you should be able to answer this question. And so here is the question. The prosecution would want to bring an expert witness who, based on the science of their investigation, should point to what as being the cause of death. What should the expert for the prosecution express on the witness stand? See if you can type in that answer. If you're watching this on a recording, say out loud and we'll take you at your word that you got it correct. But what should that expert witness for the prosecution be expressing? Give you a minute to answer that. You don't even have to read the statement of the prosecution's expert witness to know what the expert witness's main point is going to be. They're going to say that the victim died how? Well, from drowning, but how the victim got into the bathtub. What do you think? I hope you're thinking that it is due to being hit in the back of the head. And they will talk scientifically about the injuries, the wound, the structure of the room that all indicate a hit to the back of the head. So if you're paying attention, see if you can answer this question. Before we turn to the defense side, the defense saying that the suspect is innocent, that they did not commit a murder. Based on the facts, the defense will offer an expert witness. What do you think the main point that that defense expert witness will be arguing? What do you think? That they were drunk and that based on their investigation, based on the wound, based on the structure of the room, that the victim slipped, hit their head, and then fell into the tub. So that is known as the battle of the experts. And who determines which expert is more believable? And not that the experts are being accused of lying, but that the experts have conflicting scientific views. So the jury has, I'm sorry, I gave you the answer. The jury has to work through the testimony and see which one of those experts seems like they are more viable. So if you're an attorney for the prosecution and you call your expert to the stand, you want to lay out all of the testimony as to why the expert believes the victim was hit on the back of the head. But now if you're the defense attorney, you get to do something that makes our courtroom system so incredibly interesting and fair. And I use that word with quotes, and we don't want to get into what fair means and all of that. I think you understand the spirit behind the word fair. You get to cross-examine. You get to cross-examine. And it's used as the phrase cross-X. Cross-X. You get to cross-X the other side's witnesses. So what is a cross-examination? It is questions. You get to ask questions of the other side's witness. And so in this example of the expert witness who was on the stand saying for the prosecution that they believe that the victim died because they were hit in the head, you as the defense attorney will want to ask questions that make it difficult or challenge the expert witness's studies or how they reach their conclusion. Or maybe your expert has more experience. So a question may be like, hello, prosecution, forensic expert witness. You have studied 15 cases of drowning. Is that true? Yes. But now that question has established that they've only done 15 cases. You may have an expert witness who's done 25. And so you get to maybe claim your expert witness is more qualified or more expert just on experience. And then you get to go down the line. Did you run this kind of test? Well, why didn't you run that test? Isn't this kind of test a more recognized in the field as being a better test? Why did you use that test? Does that make sense? Does that sound interesting? Does that sound like fun? And I'm just identifying the challenge of the expert witness. So I wanted to give that lesson today for two reasons. One, I wanted to help you understand what an expert witness is and why they're so important and valuable. But I also wanted to give you the sense of being an attorney. So how attorneys work in this mock trial competition, but also in trials in the real world. So this is what we do. You present a witness, you lay out the witness's story, and then your witness is subject to cross-examination. The other side presents a witness, they lay out their story, and then their witness is subject to your cross-examination of them. And that goes for all witnesses, not just experts. And so let's think for a second now. The suspect in this case is Bailey Matsumoto. Bailey is the defendant. He's accused of murder. And in our case, Bailey Matsumoto will take the stand. The law, the Constitution does not require you to testify. But Bailey's going to testify. And Bailey will take the stand as the defense witness. So the defense will have a number of witnesses, one of which is Bailey. So Bailey will take the stand and he's going to testify to the fact that he didn't commit this murder. And he'll have excuses and reasons or alibis for all those points. But because he takes the stand, what does that open Bailey Matsumoto up to? It opens him up to, you got it, cross-examination. And so if you're the prosecuting attorney and Bailey Matsumoto takes the stand and has just given testimony to the fact that he didn't commit a murder, you get to cross-examine him, challenging Bailey's statements about his relationship, about his motive, about his autonomous car, about where he was, about what he did, and about whether he committed the murder or not. So it's exciting stuff. And what I'd like you all to do, even though we don't know when we'll be meeting next, we do know that we will be meeting next. What I would like you to do is read the statement by Bailey Matsumoto. And it's not short. It's long. And come up with 10 questions that if you were a defense attorney, you would want to make sure, because remember, defense trying to establish that Bailey Matsumoto is not guilty of murder. Come up with 10 to 15 questions. And if you come up with less, that's fine. If you come up with more, that's fine too. But shoot for 10 or 15 questions, knowing you're not going to be able to ask everything. And come up with 10 to 15 questions that all direct to the fact that Bailey would get to answer in such a way that help establish that he is not guilty of murder. Sound good? We'll probably try to meet again sometime in early July, probably after July 4th. So see about doing that. Just have some fun with it. Don't feel any pressure to have great questions because you probably don't even know how to ask the questions at this point. I just want your brain thinking about, can you start to decipher the most important information here? This is really an unreasonable assignment for me to kind of be giving, but I want you to play with it. I want you to be challenged. I want you to try to struggle with, do I need to ask about this or do I need to ask about that? I don't know what to do. And I want you to feel that and experience that, but also think you'll come up with some good questions. And so I'll be able to say, that was a good question. Do you see how you want to build off that? And you'll probably come up with some questions where I get to say, why would you want to ask that? What am I not understanding about what you're trying to accomplish here? And you'll go, oh, I don't know why I came up with that. That's a good point. So it's all about teaching and learning, but teaching and learning can only take place by your engaging and digging in. So that's my suggestion. And if you're at the point where you're not even able to come up with questions, don't worry about that. Just read the statement and see if you can figure out some things that are important, because it's not easy stuff and it's challenging stuff. And that's why I'm so glad so many of you are freshmen and just learning, because the teams we go up against, they have people who have been on their team since they were freshmen, sophomores, and they've been in it for years. And so it takes years. Think about law school. Law school isn't one lesson, it isn't 1 week. Law school is 3 years. 3 years. Did I say years? 3 years of learning law. So I'm gonna stop the recording. I have a phone call I have to make in 3 minutes, but I think I've given you some exciting stuff to push forward on. And even though this is the final meeting in the Law and Order portion of the summer enrichment, it is only just the beginning. So if you have any questions, give you a second to ask them. Otherwise, I will stop the recording right now.